September of 2017, same date, also put on a 5-year adjudicated probation for the state jail felony offense of possession of a controlled substance, cause number 17-26669. And so this is 17-26688. We were previously in court. Mr. Barlow entered pleas of true to counts 3, 5, 6, and 7. So we're just here in the second degree felony. The other one's already expired. I received an updated report. Have you both had an opportunity to review that report?
Yeah, Judge.
Yes, Judge. Any additions or corrections?
Oh, not from the defense judge.
Not from the state judge, other than I think we have all previously discussed this before, that the new offense allegations all occurred in Harris County, and we waited some time for those to resolve themselves, which is why we're not approving.
Okay. And they haven't resolved themselves?
No,
or they have?
No, we're currently set for trial next month. I want to say the 20th or 22nd of July.
Well, okay. So what he pled true to was failure to remain in Jefferson County, failure to report the arrest, positive urinalysis, and failure to pay fees. And everything else had to do. Let me double check. Yeah. Okay. So everything else has to do with the cases over there.
Yes.
All right, Mr. Lewis, and there was no agreement. Mr. Lewis, you may proceed.
Well, Judge, since he's been on bond, he's been on house arrest. And I think that probably was one of the best things that happened to him, because it allowed him to, one, find stable employment, which he's been able to do, and recently been able to actually find a nice stable housing situation for him and his children. He's basically operating as a single parent, because his wife still legally his wife. She's in Harris County. He's here with the children. He's raising the children himself. So he's been able to find employment, find housing, and he's been doing this on his own. He's currently even, you got to see the bandages there. He had a situation where he had a burn incident, and he still was able to continue employment and continue working to take care of the children. So I know that the recommendations, of course, of probation have been either ISF or some type of zero tolerance of high risk caseload. We would ask that he will be placed on some type of high risk caseload where he will be able to continue that on, because I think any type of incarceration right now would be counterproductive with the progress he's made over the last few months, Judge. And given his motivation, I think it'd be really good for him if we can continue that on, to especially taking care of those children.
Ms. Golfino?
Judge, I'd like to see if Mr. Kitchens has anything to add other than his report. I have a couple comments.
He has been doing, since he's been on bond and house arrest. I will agree with Mr. Lewis saying he's got a different attitude. He has been tested positive with the probation department, and it sounds like it's made a difference.
Okay.
And that's what I wanted to see, Judge, if you concurred with that. I would agree with Mr. Lewis that as many times as we've dealt with Mr. Barlow on this case, on other issues in the past, I mean, I felt like I've had him on my caseload for 5 or 6, 7 years. I don't know that derailing him now is beneficial. I know that the issues with this female friend or wife or whomever is obviously, you got to get that straightened out.
I'm sorry to interrupt. What's the long-term?
Actually, when y'all put me on house arrest, that kind of like, it was hard for me to get away from, because of my wife and my 2 kids. When y'all put me on house arrest, I've been on it for 6 months. So no contact. Only way I can contact through my mom. So the feeling that I had before is gone. Finally, y'all gave me a chance to get a job. I thank you for that. Got the job, worked as a regular worker. They just upgraded me to a supervisor. Been trying to pay 2 or 3 times a week, month. You know what I'm saying? I've been clean. I've been happy that I could take care of my kids and do things I couldn't do, which was real hard for me at the time because I was so focused on her. But through these 6 months, y'all kind of fixed me to a different position to see that I can do better without her.
So the long-term plan is not to try to reconcile or get back in that situation.
It really just it pushed me away because without this, I probably would have been still trying to be in a relationship with her, try to keep my family together. And Mr.
And
Lewis
sometimes that's not the best thing for the
Mr.
kids.
Lewis had conversation with me as well on the side after coming from court in Houston and saying maybe this ain't what. You know, my dad haven't been there to tell me nothing. I've been dealing with Mr. Lewis about 8 years, and like I told him, he done told me a lot of father figure things that kind of dome my brain that I couldn't even focus on without another male person that's in a good position in life to kind of direct me. So it kind of put me in the right stand. And Mr. Kitchens always was out to hear what I had to say, and I appreciate him as well.
Well, here's the thing, Mr. Barlow, if I give you this opportunity today,
Yes.
you have got to take advantage of it because you're not going to get this opportunity again. You've got everybody behind you. Mr. Lewis has worked very hard. I've signed, I don't know how many times he's sending over emails. Can he go do this? He's got a job. Can he? And I want you to do all those things that are positive, but you've got to stay on the positive track when things kind of lighten up a little bit eventually on probation. You're going to have to do it on your own. So what I'm going to do, I'm going to find that you entered your pleas of true to counts 3, 5, 6, and 7 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. I am going to order that you're on the high risk specialized caseload and that it's zero tolerance. That means you just have to do it all right. You know, there's no hiccups anymore, no contact, communication with Miss Foster.
Yes.
Continue doing what you need to about your kids through your mom. If that's working, then that's great. Use that. If that's not working, then there needs to be something else done. And I would think that to help you guys, it's once you get this taken care of, you need to save up what you can and get someone, you can talk to Mr. Lewis about helping you through the family court system so that y'all have some orders in place with regard to the kids. And there's not all of the communication that you might have to have now because things aren't set on who has what and doing what. But as far as I'm concerned, this is going to be your opportunity. No contact. I mean, I'm not going to leave you on house arrest anymore. I want you to go work and do those things. You cannot leave Jefferson County. If she comes to Jefferson County, you better avoid her. If she shows up, you better go lock yourself in a closet and call the police and say, I'm trying. She's bothering me. She can't give you permission to violate my order. Okay. So she can't say, it's okay. Let's just talk about the kids. It's not okay because you're going to end up in prison, not her. Does that make sense?
Yes, ma'am.
All right, so I'm handing you the trial court certification. This wasn't an agreement. You can talk to Mr. Lewis about that. And if there's anything else, Mr. Kitchens, that comes up that you think would be a good condition to add that would help Mr. Barlow, then just let me know and we'll make that happen. Good luck to you.
Yeah.
Morning.
Good morning. Please.
Good morning. Are you Claire Beal?
Yes, ma'am.
And Ms. Beal is charged with unlawful carrying a weapon on alcohol premises and cause number 26 DCCR 0224. And Mr. Rojas, what is the announcement?
Judge, I'm asking for another announcement date. I don't know if this qualifies, but I'm gonna ask Mr. Canal for pre-trial deliberating in this case.
Okay. Any issues?
No, Judge, and we have extended an alternative offer if she's not free for that.
All right, so Ms. Beal, I'm going to reset your case about 30 days or so Mr. Rojas can make that request. Stay in touch with him. He'll let you know what he finds out, and then we'll see you back at the next court date.
Yeah.
You're free to go.
Oh.
Corbin Rayleigh. Good morning. Are you Corbin Rayleigh?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Raylene, cause number 25 DCCR 1482. You're charged with the state jail felony offense of engaging in organized criminal activity. And that's from September 28th of 2025. And how do you plead to that charge?
Guess guilty, right? Something, right?
So did you do this?
Did you do it or did you not do it? If you did it, it's guilty. If you didn't do it, then it's not guilty and we have a trial.
I committed a misdemeanor. I know that.
The underlying offense is a misdemeanor assault, Judge, because it was in combination with 3 people or more. He feels it should be a misdemeanor, but Mr. Coleman and Mr. Nichols would reduce.
And you've talked to him about
We have.
what engaging in organized criminal activity means. Have you-
We have.
So you've gone over all of this with Mr. Rojas, right?
A little bit, yeah.
All right, I'm gonna hold the case. Y'all go talk.
Yeah.
Ask any questions you have of Mr. Rojas. Listen carefully to his answers. He's
Yeah.
telling you what the law is, and then we'll decide, you can decide if you want to take the deal or not, or if you
Yeah.
want to go to trial. Mr. Wilkerson, you've got Richard Couch. It's a sentencing.
Yeah, sure.
Judge, we actually signed new paperwork. We had a discussion this morning. Where he no longer wanted probation, so we made a time offer.
Okay,
There have been some life circumstance changes
okay.
since between the time that we had entered the plea and present day. And so given the stringent requirements of probation, including those financial requirements, he feels like he would be better served by going ahead and
Okay. You're sent, you might have done it, but it didn't come through on the bottom of the Wilkersons. So since we've already gone through the plea,
We
I
have,
don't
we
know
have the
that I-
PSI report, Your Honor. and
so I can just go through this new paperwork with regard to the new punishment page, but we don't need to get a new plea or anything like that.
I don't.
Correct?
no, Your Honor.
Everybody agrees. All right, so you're Richard Couch. And Mr. Couch, you were previously in court and entered a plea of guilty to driving while intoxicated, third or more, in cause number 26 DCCR 0142. When you did that, the agreement was for a 10-year term in prison, but that would be probated and it would be up to me on how long your probation was. And I've got that pre-sentence report, go forward with sentencing today. And as you can hear, it's my understanding that you have come up with a different agreement with regard to your punishment. Is that correct? And that is shown here on the documents that you signed with Mr. Wilkerson today on the tablet. And did you go over those with him today with regard to that new agreed punishment recommendation?
Yes, ma'am.
And you want me to go forward with that today and sentence you in accordance with that agreement?
Yes, ma'am. I just asked if I can get my affairs in order and.
We were talking about him maybe reporting Friday at 6 p.m., Judge, but he is ready today if you can.
Well, I mean, so here's the thing. I'm not going to sentence him and then hope he reports, because that becomes a problem if he doesn't, since the case is technically over. So I can reset sentencing for next Monday, or I can sentence him today. But I'm not going to, I can't do the sentencing and then,
Either option's fine with the state, Your Honor.
Judge McCline's indicated that he would like to reset sentencing to next Monday if possible.
so, okay, so state tenders these new documents as exhibit number 1, Mr.
No.
Wilkerson.
No objection, Your Honor.
They're admitted. And so here's what I'm going to do, Mr. Couch, and I want to make sure you understand how important this is. I'm going to reset your case to next Monday morning at 9 o'clock. Come in, I'll go through this real quick, get your sentence, and you'll go with the bailiff and start that sentence. If you are arrested for anything between today and next Monday, then it is very unlikely that I will accept this agreement. Things could be much worse. You understand?
Yes, ma'am.
Also, if you don't show up next Monday,
Yes, ma'am.
things would obviously be a whole lot worse. You understand?
Yes, ma'am.
Okay, we'll see you back next Monday then.
Thank you, Your Honor.
Thank you, Your Honor. Big excuse.
Thank y'all. Yes, sir. On Mr. Adams. Do I not have,
No, she couldn't go, she's ready to go now, we're gonna take a break.
okay. You can go ahead. I'm waiting on Mr. Adams and Mr. Gertz, and Mr. Rojas is going over that. 25 DCCR 1482. How do you plead?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state marks as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Do you understand?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Rayleigh is not competent?
No, Your Honor.
So, Mr. Rayleigh, your unwillingness today at first to take responsibility gives me some concern.
Yeah.
What you guys were doing that day was absolutely ridiculous.
Yes.
And somebody could have been seriously hurt.
Yes, ma'am.
A paintball can cause all kinds of serious bodily injury.
Yes, ma'am. And I told Mr. Rojas I'd be willing to do anything civil matter with the victim. You know, I'm not a just horrible person. I'm a
No, I mean, y'all, it was just,
complicated.
it was ridiculous
Yes,
and stupid. And
yeah.
you're lucky you're not here for an aggravated assault with a deadly weapon by shooting an eye or shooting somebody in the head in the wrong place.
Yes, ma'am.
3 people were shot just driving. You're lucky that y'all didn't get shot because somebody didn't think it was a real gun. And that's what people are doing everywhere now, is shooting people. So you're out there with a paintball gun, but you in turn could end up shot. So I just want to make sure you understand that giving me an opportunity to review this gives me some concern. You need to take advantage of this opportunity. You're very young. There's no reason for you not to be able to be successful and make some better decisions. But you need to understand the importance of this as felony court. Doesn't have anything to do with civil court, doesn't have anything to do with paying them back. It has to do with you doing your probation right. And if you don't, you go to prison.
Yeah.
All right. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing just so I can get a little more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right? See you back at sentencing.
Yes, ma'am.
Thank you, Judge.
Thank you.
Thank you, Mr.
You're welcome, Mr. Rowan.
Miss Williams? All right, Miss Williams, you tested negative, which is obviously good. You just look very kind of out of it and tired this morning. I'm sorry?
I don't get in trouble.
You don't get in trouble? Well, you're in felony court, so. So you're in some trouble at least. So let me go through this with you. This is your initial appearance, Miss Williams, in cause number 26 DCCR 0804. And in that case, you are charged with the 3rd-degree felony offense of theft of property, and that's from January 24th of 2026. And so since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
All right, so what I'm going to do, Ms. Williams, is reset your case for about 30 days to give you some time to try to hire someone. If you get a lawyer hired before the next court date, then just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand?
Yes, sir.
All right. It's obviously very important too that you don't use any type of substance that would test positive. Okay.
Mhm.
All right. Step in front of the clerk. She'll give you a reset notice.